step in this matter?
No, I want
Why
to,
this court step in this matter?
The
reason for
let me read how the case progressed thereafter.
What do you suggest? In this matter also, we should constitute a committee to provide us inputs for taking a final decision in the matter. Step in this matter.
No, I want
Why
to,
this court step in this matter?
The
reason forthcoming was,
yes,
at a given point of time, there are a good number of politicians who are under the reign of investigation. Maybe some cases. CBI was the agency who had to investigate. This court felt, and we also know the ground realities. The court wanted that CBI must independently investigate all matters, regardless of the fact who politician and who may be. The procedure for appointment of director was still there. It's not that it was not there earlier. And only after this court step in, the mechanism has come forward for appointment of a director. But the court felt no, that mechanism may not be fair in dealing with the nature of matters which are coming up for the CBI to investigate. Let us put in place an independent agency in making an appointment to hold the post so that an independent investigation, even in the cases of politicians who are coming forward at a particular point of time, they also have a fair nature of investigation. That's why this court step in. Otherwise, minus Vineet Nandan, as there was no provision how to the director of CBI to be appointed. There was a provision.
Yeah.
And appointments were made.
Yes.
Nobody questioned it. This court also never stepped in.
Let me read how the case progressed thereafter.
The initial paragraph itself.
Yes, right.
This court has disclosed why we are stepping in.
Let me try to pick out a leaf from this.
There are 7 or 8, I think.
I'll just come. There are 26. I'll just come to that. The need for insulation of these agencies from extraneous factors which may deflect the fairness of investigation and therefore entirely compromising the investigation process. Regardless of whoever they are who are in deflecting the investigation process, if that's going to actually reflect, the court says
how to insulate this post of a chief election commissioner.
I'll just point out what happened in this case. Little further. I find from the report that they appointed an independent review committee. The independent review committee came with a set of recommendations. And the recommendation of the independent review committee has been accepted by the court. Virtually, whatever were the recommendation of the independent review committee has been simply endorsed by the court. The court has not independently taken an analysis of the recommendation, entered into their evaluation, and the need for ABCD to be accepted, EFG not to be accepted. No. The entire set of recommendations, which emanated from the experience of those who were in the committee, being party to the civil service. They've been there for long. So therefore, this is a case where those recommendations, without any further elucidation or evaluation, the court simply says this can be accepted. Kindly turn to paragraph 25 at page 249, and thereafter.
What do you suggest? In this matter also, we should constitute a committee to provide us inputs for taking a final decision in the matter.
No, I'm not suggesting. I'm only saying that look at the facts of that case. I'm not saying there can be a circumstance when there is no committee at all. I'm just in the abstract. Suppose there's no committee, there's no inputs, but a violation of fundamental right is brought to the notice of the court. Then what is it the court will do? The court will ask for inputs in order that this is how the violation of fundamental right takes place. And those inputs will be essential inputs for comprehending how to avoid a violation, how to avoid a breach of a fundamental right. Then the court will be in a better position to go into that exercise. So therefore, I said this is a case where there was a set of recommendations which was simply accepted by the court. There's no evaluative criteria. There is no further consideration.
Court also considered at the subcaption, the caption to page number 255, the need for court's intervention Here also that is very relevant. The need for court's intervention. Whether that is there or not. That is the first question. At page 255.
Page 255.
Then the power of the court, that was also another subheading. The power of the Supreme Court. So these aspects were considered.
Correct. Absolutely.
So here also we will have to consider the need for court's intervention, whether that is required, and then the question, the power, to what extent.
Absolutely right. Because that's why on the facts of that case, if the government itself felt there is a need for looking into it and gave a set of recommendations, the importance of it is being underlined by the court. There's an emphasis given by the court to say, yes, we see the importance. If the court has not intervened, what would have happened is anybody's guess. Whereas the IRC recommendation would have remained, but the IRC came in the course of all the deliberations. It happened like that. So in the course of the deliberation, there is something available before the court. So that makes it again a concrete situation when the court is in a position to enter into even a minimal evaluation or a minimal consideration. Therefore, Vineet Narayan stands in a slightly different footing. And I say the need for court intervention, before we say that, in paragraph 25 at page 249 onwards.
In this case also that should be considered, the need for intervention.
No, I'm not anyway disputing on the need for intervention. I don't think anybody would have said that. What I'm saying is on a slightly different dimension. Page 249 to 255 are the set of recommendations which the IRC has placed before the court. Those set of recommendations you'll also still find after the paragraph says so and so, containing discussion pertaining to the Central Bureau of Investigation, Central Vigilance Commission, Directorate of Enforcement in Part 2, recommendation therefore to be read along with discussion in the corresponding paragraph. Then in paragraph 26, immediately after Placitum E, when the report of the IRC is set out, just above Placitum F, there can thus be no doubt that there is a need for the exercise you are called upon to perform, and this is occasion consideration is crucial issue to this court to exercise powers conferred by the Constitution of India. The conclusions reached by the IRC and the recommendation it has made for improving the functioning and thereby the image of the agencies is a further reaffirmation of the general belief. No doubt that the conclusion reached by the IRC and recommendations are the minimum which require immediate acceptance and implementation of it to help any further delay of the polity. Exercise to be performed by the court is really to consider any notifications required to make the recommendation of the IRC for achieving the object for the central government itself constitute IRC. We informed by the Attorney General for the action the report IRC could not be taken so far because of certain practical difficulties faced by the central government. But there's no negative reaction to the report given by the central government. So that is why the court proceeded to, yes, we give our imprimatur. In paragraph 48, in view of the page 264, in view of the common perception shared by everyone, including the Government of India and the Independent Review Committee, the need for insulation of CBI for extraneous influence of any kind, it is imperative that some action is urgently taken to prevent the continuance of the situation, with the view to ensure proper implementation of the rule of law. Therefore, here is a common perception which was the basis for the court to proceed further. Then turning over to paragraph 53 at page 266. On this basis, we now proceed to give the directions enumerated hereafter for rigid compliance till such time the legislature steps in to substitute them by proper legislation. These directions in Article so and so implement the rule of law wherein the concept of equality is embedded as the force of law under Article 141, so and so, etc. Judicial and Territory of India to act needed to the court. Then 54, before that, we have accepted and are reiterating as far as possible the recommendations made by the IRC. So these recommendations you all look at paragraph 58 are virtually a verbatim reproduction of the IRC recommendations. It says in exercise of the powers, 32-142, guidelines and directions have been issued, large number of cases, and brief reference, a few of them is sufficient. So Kanga with the Union of India, Constitution is laid on certain guidelines relating to Immigration Act, Lakshmikant Khande, guidelines for adoption of minor children, then Sampath Lal, Veeraswamy, etc., guidelines were laid down having the effect of law requiring rigid compliance. For instance, skipper construction was a real estate issue where you violated the law, breaches of law, and then advocates in the court association, and 9-judge bench, the appointment transfer of judges, which are being rigidly followed matter of appointment, so and so. More recently in Vishaka, elaborate guidelines have been laid down for observance in workplaces relating to sexual harassment of women, so and so. Vishaka, we said, the obligation of this court under Article 32 of the Constitution for the enforcement of these fundamental rights in the absence of a legislation must be viewed along with the role of a judiciary envisaged in the Beijing Statement of Principle for the independence of the judiciary in the Asia region. These principles are acted by the Chief Justice of Asia and Pacific Council in Beijing as those representing the minimum standards necessary to be observed in order to maintain the independent and effective functioning judiciary. The objective judiciary mentioned Beijing Statement of so and so. And after setting out that, then there's an exercise of this kind. But this court is now a well-settled practice with a taken firm roots in constitutional jurisprudence. Exercise essentially fill the void in the absence of a suitable legislation to cover the field. So that proposition will always be subject to adjustments, modifications, qualifications, and caveats. So when you draw it so over broadly, and we want to apply it in a particular situation, then court will always ask this question. Is there a legislation which is contemplated? Or it is generally the constitutional obligation to cover a field, to be proactive under the Constitution, and therefore protect fundamental rights. That's where Vishaka comes in. So if you're not proactive and protect women in the workplaces, I just want to digress here for a minute. After Vishaka, there are two petitions are filed, one in Delhi High Court, one in Supreme Court, on guidelines you framed as far as courts are concerned. And guidelines were framed, Mr. Nariman was involved in that, guidelines were framed. And those guidelines were prior to the 2013 Act being enacted. And after the Act came into force, question arose whether these guidelines framed were in consonance with the Act or not. I happened to be heading a committee asked by the court to give a report to the court on that issue. I found there is some dissonance between the guidelines and the Act, particularly because the peculiar nature of a court as a workplace and how to really you adapt those set of principles to court as a workplace. There were some issues. I've given a report. It's still pending with the court for consideration. Why I want to say this, there can be occasions when you move forward, a law comes in, but still there are unattended issues or unexplored dimensions of an issue, which may still call for an understanding and moving further. So therefore, why I want to draw this example is, we have a situation on hand where the question is not merely answered by saying there are these kind of recommendations are there. We find that over a period of time, that the process of appointment or the persons who are being selected and how they really serve the institution, there are some issues or questions which seem to be emanating. Therefore, on those perceptions, we find that we say there is a mandatory obligation for the state to move into this. That is where I keep encountering some difficulties in saying, yes, this can be done, cannot be done. So, Vineet Narayan may not be a clear and a direct proposition to say that the court will do, because here, except those to equate the IRC recommendations to, Lordship.
The point you are actually laboring to make is,
yes,
and which perhaps we may have to get a response from them. We need in Vishaka, paragraph 16 of Vishaka, the court says, in view of the above and in the absence of enacted law to provide for effective enforcement of basic human rights, etc., we are issuing guidelines. In the case of Vineet Saran also, the court of course went ahead and said it must be made a statutory right, an extraordinary
right.
What you're saying is that in a constitutional provision in particular, when the founding fathers have provided for the mechanism for appointing the chief election commissioner and the election commissioners, there is no vacuum. Because the president means the council of ministers. Now, as to whether it is a satisfactory state of affairs, there could be a more ideal state of affairs, a better state of affairs, debatable. Whether that will provide us with a scenario which is similar or identical with Vishaka, no.
I understand.
No.
I understand.
So, therefore, your argument is really there is no vacuum
That's right.
in which the court can really step in.
Right.
Unless we say that we are going to rewrite Article 224(2) in a manner to speak.
That's
Supply and omission, causes omission, which
that's right. That's
the law is that ordinarily we shouldn't be.
you're right. Right.
So we are stepping in on, like you said, idealistic content, aspirations.
That's why I use the word aspiration. I'm using it in a very, very highest level of its content and meaning.
No vacuum. You're basically, there is no vacuum.
Right. And that could be a good aspiration. I don't think one can even debate about it. So that's where the line of demarcations may.
I'll answer that whenever your lordship wants me. There's a straight, simple answer.
So the moment he
etc. That cards case where eavesdropping, US Supreme Court were called upon to decide whether electronic eavesdropping would be an invasion of your, an injunction against searches and seizures. So the Fourth Amendment to the US Constitution said illegal search and seizures are prohibited. So courts went on to decide eavesdropping is well known, but electronic eavesdropping, is it a search or a seizure? The majority went on to say the Constitution provides persons and not places. That's how they answered that question. Justice Black in his dissent says no, you can't look at a perceived constitutional silence there and therefore try to give a meaning which the constitution makers did not even contemplate. That's right. So your perceived constitutional silence can sometimes be a very debatable area. That's where both eqnuire and Vishaka are not in that category at all. There's a women's right and dignity at workplaces, and it's a matter of immediate action, urgent action. It can't prove delay, and we can't fall back merely on a constitutional reading of Article 21. We need some effective working machinery. Therefore, there is a need to fill up that immediate need. That's how Vishaka came in. I also keep wondering, after Vishaka, the court has gone further again on what called exercising its constitutional deliberative engagement only with a view to ensure that fundamental rights get their due. So beyond that, in order that the court enters into that kind of an exercise, there must be I'm repeating, there must be a live connection between the issue and the fundamental. So that's why paragraph 16 takes care of it. Raja Rampal for opinion. This is 2007 3 SCC 184. This was Article 105.
privileges.
Immunities, powers, and privileges for the House of Legislatures. A long debated issue, both, and then from Keshav Singh onwards.
House of Commons. Finally, they say this House of Commons power is there. That's
Sorry.
it'll be the same.
What is the context in which this issue came? 239. The interpretation of Article 105 of the Constitution of India is an issue in this matter. Question is whether in exercise of the powers, privileges, and immunities contained in Article 105, are the Houses of Parliament competent to expel their from are competent to expel their respective members from membership of the House. If such power exists, is it subject to judicial review, and if so, the scope of such judicial review? The unfortunate background in which the opposite questions were written in the allegation members of parliament indulge in unethical and corrupt practice of taking monetary consideration and in relation to the functions of the MPs. A private channel telecasts a program so depicting 10 MPs out of the people and the council of so-and-so, accepting money directly or through a middleman as consideration for raising certain questions or otherwise espousing certain causes for those offering the bouquet. This led to the extensive publicity in the media. Presiding officer of which parliament instituted inquiries through separate committees. Another private channel telecasts a program alleging improper conduct of another MP so-and-so in relation to the implementation of the Parliament Development Scheme incident also referred to a committee. Then report of the inquiry concluded the evidence against 10 members of the Lok Sabha was incriminating. The plea that the video footage is doctored, morphed, edited and no merit. There was no valid reason for the committee to doubt the authenticity of the video footage. The allegations of acceptance of money established acts of the acceptance of money direct connection with the work of the Parliament and consider such conduct on their part as the unbecoming member of the Parliament and also unethical and calling for strict action. Then, little later, Placitum G, the majority report recorded the deep distress over the acceptance of money and for raising questions now, found it eroded the credibility of Parliament, the institution and pillar of democracy, and recommended expulsion of the 10 members. Then, paragraph 5, next page. On the report of the inquiry committee being laid, a motion was adopted the Lok Sabha resolving to expel the 10 members of the membership, accepting the finding as contained in the report of the committee, the conduct of members was unethical and so and so. On the same day, Lok Sabha Secretary issued the impugn notification notifying the expulsion of the MP, so and so. Then, the almost similar process adopted in undertaken in Rajya Sabha, matter referred to the Ethics Committee. Then the committee found member had accepted money for tabling questions, and that's how the then para 7 report of the Ethics Committee was adopted to the Rajya Sabha, and the notification notifying expelled member was issued, and that's how the matter came to the court. Para 9. The two members of the Rajya Sabha have also challenged the constitutional validity of the expulsion article 105 is as follows. Then there is para 10, identical provision 194. Then paragraph 13, their contentions at page 242. The petitioners submit that all the powers, privileges, and immunities are vested on the date of commencement of the Constitution of India in the House of Commons and so on, so had not been inherited by the legislatures in India under Article 105 of the Constitution. Main contention urged that the power and privilege of expulsion is except by the House of Commons as a facet of its power of self-composition, and since such power of self-composition has not been given by the Constitution to Indian legislature, it did not inherit the power to expel its member. The contention is that the expulsion is necessarily punitive in rather than remedial, and such power vested in the House of Commons as a result of the power to punish for contempt in its capacity as the High Court of Parliament, since the status was not accorded to the Indian legislature. The power to expel could not be claimed in the House of Parliament under Article 1053. It's also their contention the power to expel cannot be asserted to Article 105.3, also for the reason that such an interpretation would come into conflict with the constitutional provision. A grievance has been made about denial of principal naturalization, inquiry proceeding, the gross and patent illegalities, and so on and so forth. Then, just after Placitum C, the petitioners submit at page 243 that the constitutional and legal protection accorded to the citizens would become illusory if left to the organ in question to determine the legality of its own actions. They further submit it's also a basic principle of law, rule of law permeating every provision of the Constitution. Rather, forming its core essence that the exercise of power by the executive authority must not only be conditioned by the Constitution but also be in accordance with the law. In this context, it is primarily the function of the judiciary alone to ensure the law is observed and there is compliance with the requirement of constitutional provisions. Then paragraph 16. It is a petitioner's contention. House of Parliament had no power of expulsion of sitting a member. They plead the petitioners could not be debarred from membership by an order of the impugn notification pursuant to the proceeding consequent upon the media reports, as the substantive and adjective law had been disregarded and the constitutional inhibition placed in the exercise of power of debarment had been defeated. On the case that Indian legislatures cannot claim the power of expulsion members, the contention stated this. Then just look at the legislature has no power to expel members since Parliament has not enacted any law which provides for expulsion of member in a specified circumstance in terms of an enabling power to legislate on the subject as available in Article 105 of the Constitution. Then 3, they're talking about no provision either in the Constitution of India or in the rules of procedure and conduct of business for the expulsion of a member by adoption of a motion under the Issued Act beyond the jurisdiction of Parliament.
Yeah.
Paragraph 36 at page 249. Having given our anxious consideration to the myriad issues that have been raised on both sides of the divide, we have found that the primordial question that need to be addressed by the court can be formulated as under: does this court within the constitutional scheme have the jurisdiction to decide the content and scope of powers, privileges, and immunities of the legislators and members? If the first question is answered in the affirmative, can it be found that the powers and privileges of the legislature in India, in particular with reference to Article 105, include the power of expulsion of the members? In the event of such a power of expulsion being found, does this court have the jurisdiction to interfere in the exercise of said power or privilege conferred in the rules on Parliament and members of committees and so, and if so, the jurisdiction circumscribes certain limits? Then kindly turn over to page 250, paragraph 43.
Yeah.
As can be seen from the language employed in Article 105, Parliament is empowered to define by law the powers, privileges, and immunities of each house and the members and committees in respects of other than those specified in the constitutional provision. Though some part of the arguments advanced by the petitioner did try to refer to certain statutory provisions. For example, provisions contained in sections 8 to 11 of the Representation of People Act as referable to the enabling power given to Parliament in the first part of Article 1053. But for present purposes, we assume that Parliament has not yet exercised the said enabling power, in as much as there is no law enacted till date that can be referred to as cataloguing the powers, privileges, and immunities of each House of Parliament and the members and committees. This consequently leads to the continuity of the life of the second part of Article 1053, in as much as that part of the provision was designed to come to an end as soon as Parliament defined by law its powers, privileges, and immunities. Therefore, powers, privileges, and immunities not having been defined, the question as to what are those powers which are enjoyed by the House of Commons at the commencement of a constitution, that will determine the powers, privileges, and immunities of both houses of the Indian Parliament. Therefore, in a context like 105, we did not group delay, and if it is a transitional provision, so you don't look back to the House of Commons or what were available in England. So even in that context, if Parliament has not enacted, what should happen? Was the anxious consideration before the court.
That was not the issue there.
I know, but I thought it's important to just to have place it in its position, that's all. So if your comparison with 324(2) and 105, if it is opposite, then there is something to be drawn from this judgment.
No, but what conclusion you want us to draw from this authority?
This authority, we want to say, kindly turn to para 166.
Yes.
The court, even after noticing the importance of the need for a parliamentary intervention in this matter, to define the scope of powers, privileges, and immunities, which are as equally important for the purpose of Article 14, Article 19, 1A, and even maybe Article 21 in current point of thinking. Even if in that context, if there is no law, Parliament has not intervened, the court did not think to go far.
Parliament to.
That's right. Therefore, I'm only drawing a parallel between the importance of that constitutional provision and that constitutional scheme vis-a-vis 324(2). I don't think we can have something on a different pedestal. Both are equally important. I'm not saying that the higher importance is lower.
The privileges enjoyed by the members of the House of Commons.
That's right. Therefore, the court felt there is no vacuum.
There is no vacuum.
There's no vacuum.
That is the point. That is the distinction.
First, it is to be remembered that Article 1053 is itself a constitutional provision. And it is necessary that we must construe the provision in such a way that a conflict with other provisions is avoided.
Yes.
We are of the view that where there is a specific constitutional provision as may have the effect of curtailing this fundamental right, if found applicable.
Yeah.
if found applicable, there is no need for a law to be passed in terms of Article 19(6). For example, Article 102 relating to disqualification provides that members who are of unsound mind or on undischarged insolvency declared by competent court are disqualified. These grounds are not mentioned in the Representation of People Act 1921. Though this provision would have the effect of curtailing the rights under Article 19(1)(g), we doubt that it can ever be contended that a specific law made in public interest is required. Similarly, if Article 1053 provides for a power of expulsion, it cannot be said that a specific law in public interest is required. Simply because Parliament is given the power to make law on this subject is no reason to say that a law has to be mandatorily passed when the Constitution itself provides that all the powers of the House of Commons rest until such a law is made. A question may be put to me that, well, there are some existing safeguards available, we borrow it from the House of Commons, therefore there is no vacuum. But here we find that the process of appointment throws some doubt about whether this would be the most ideal way of going about it. Therefore the connect may be little open to question. Your Lordship may put the question to me. I am bound to answer that. But I thought just to draw those conceptual parallels are important.
You have understood.
I only try to draw that. I would take your Lordship through some of the judgments. Before I do that, maybe I think I can continue tomorrow. I wanted to give some information on the Law Commission issues, how many reports. I just share some information. I'll put it on a small note and give it to your Lordship tomorrow. There are more than